27 stab wounds, a slit throat, a gunshot wound to the head, and yet the defense claimed self-defense. If you watched the Jodi Arias trial and thought, how could a lawyer argue self-defense? Well, today you're going to understand exactly how, exactly why, and exactly how it all fell apart. Welcome to Courtroom Autopsy, where criminal lawyers dissect infamous trials. I'm David Lish. This is Ryan McPhee. We've prosecuted cases, we've defended them, and today we're going to put every aspect of the Jodi Arias case under the microscope. You're going to understand exactly how this case played out in court and why. Today you're going to see how Arias' attorneys defended her, or tried to, how prosecutorial misconduct permeated this case, and how the Court of Appeals allowed the guilty verdict to stand. Let's start the autopsy. So Ryan, let's get into Jodi Arias. This is one that I've been hoping to do for a while. I know you have too. It's one that, if you remember back when this trial was going on, the phrase that sticks in my mind on this case is media circus. Do you agree?
Yeah, absolutely. I think I can't think of a bigger case in Arizona as far as the media goes, as far as everybody knew what was happening. Everybody was involved. I think it's interesting, both you and I worked at the county attorney's office at the time.
That's right.
Maricopa County Attorney's Office. And so even the prosecutors, right? Like, were involved. We had the trial on in most rooms, that we were in, at least when we weren't actively working on cases.
Yeah, and so this case, of course, was a big deal. So let's back up just a minute. Let's tell the story. I think a lot of our viewers know a little bit about the Jodi Arias case. Maybe you've seen, right, maybe you've seen things, or maybe you watched the trial, but let's just back it up. So 2006, Jodi Arias meets Travis Alexander. They have, this, what do you call it? A very rocky relationship, a very toxic relationship, I think is the right word. And then in June of 2008, a string of events happens where Travis ends up dead. And leading up to that, Jodi had engaged in some bizarre behavior. She had staged an apparent burglary of her grandparents' home in California. She had taken a trip, gotten some gas cans in her car to, she said she was going to be driving through the desert.
Turned off her cell phone so that she couldn't be tracked. And that's pretty forward thinking back in 2006. I thought it was interesting, Dave, both you and I live in Mesa.
Right.
This happened in Mesa. So I looked up where Travis's house was. It's 3 miles from our Mesa office. It's 3.5 miles from where we live.
Right.
It's right there. It's interesting.
Yeah. So local crime. And it got a lot of media attention at the outset because you have this young, attractive girl who is in this toxic relationship with Travis Alexander, and Travis ends up dead. His body was discovered in the shower of that Mesa home that you described. He'd been stabbed 27 times. His throat had been slit
so badly.
A gunshot wound to the head.
They say that the slitting of the throat was so bad he was nearly decapitated as well. It was ugly. Travis was widely understood to be a very loved guy. A ton of people knew him, loved him. Interesting, he was involved in this kind of sales community for Legal Shield, which is something that most lawyers are aware of as far as how that works. It's like a thing where these companies pay, and then it's almost insurance for lawyers. It's kind of...
Yeah, and one of the things I think that's important to understand about what we're doing today is, there's a lot of drama, and I know there's been a couple of movies that were made about Jodi Arias. I want to try to step away from this sort of sensationalism that took place, the drama about Travis and Jodi, and really focus on, like we do, what happened in that courtroom.
Yeah.
This was a lengthy trial. It took place in Maricopa County Superior Court. The judge was Sherry Stevens. The prosecutor was Juan Martinez. The defense team was Kirk Nurmi and Jennifer Wilmot. Regular people, regular lawyers and judges that we interact with on a regular basis.
Yeah, and anybody who's watched any of our episodes are going to recognize that name. Juan Martinez
Right.
prosecuted a lot of high-profile homicide cases. We will talk a lot about him and his behavior during this trial and what that led to for him eventually, which we've kind of been leading up to, I think, as we've talked about his behavior and his style as he prosecuted cases even leading up to this. But this really, I think, was the end for him as far as prosecuting.
Really the tail end of his career, and we'll talk about why. So let's just flesh out a few more of the facts just so the jury understands. So Travis's body is discovered. It's brutally treated, lots of stab wounds, slit throat, bullet wound to the head. Arias, when police go to the scene, she's not there, but she ends up calling a detective and speaking with a detective who was at the scene. She wasn't a suspect at the time.
While they were on scene.
While she was on scene, she's on the phone with them. She denies even being in Arizona originally. And then later, she changes her story, and you're going to see, we all know that she spoke to the media, but she also gave a number of different versions of what happened. She admitted to later being in the victim's home at the time of his death, claimed that 2 armed intruders came in, murdered him, and she fled for her life. There was a .25 caliber bullet casing that was found at the scene. One of Arias's hairs, a palm impression. There was a camera in the washing machine that was pretty important because it contained photos. Yeah. It documented their sexual activity, and then a picture of him immediately before his death. Go ahead.
Well, that's what I was going to say. Just that camera turned out to be, it was in the washing machine. It looked like some of the sheets from the bed or whatever, maybe in an attempt to destroy physical evidence that they'd been in the bed together. There's speculation on what happened there, but the camera was washed in the washing machine. You remember those cameras that had just a
memory card,
an SD card, right? That was just fine, and that they were able to pull those images from, which not only captured their activities that the day of the murder, sexual activities between Jodi and Travis, but also actually it looked like inadvertent photos taken during the attack that actually captured pieces of her and Travis.
So a couple of things to keep in mind. Travis suffered 3 fatal injuries, according to the medical examiner. A knife wound that pierced his heart, a neck wound that perforated his jugular vein and carotid artery, and then a gunshot wound to his frontal lobe. Also, there were numerous non-fatal stab wounds and defensive wounds, making it appear as if he had tried to fight off his attacker. He was alive when many of these were inflicted. 9 of the stab wounds were consistent with the victim having had his back turned to the attacker, and there was one deep wound to the back of his head. Okay, so brutal murder. And the medical examiner also said that he may have already been dead at the time that he was shot in the head.
Yeah.
Okay. Ultimately, Arias, though, admits to killing Travis, claiming later it was self-defense. The defense put on experts talking about PTSD and sort of a battered woman syndrome type of defense, meaning she was in a helpless position, tried to get away from this relationship, and it was all that she could do to get away by killing him.
Yeah, and it's an interesting defense, right? Because generally self-defense, and again, we've talked about this, in order to be successful in a self-defense argument, the defense has to show that there was imminent threat, that they were imminently going to be harmed or killed in order to use the appropriate force against the other person, where this is a little bit of a twist on that, right? And you might be able to shed a little bit more light on this, where they say, even though maybe at that moment it wasn't imminent, even though she did argue that, she said that he was lunging towards her and trying to harm her at the moment, this battered woman or battered partner syndrome talks about how their reaction to things or their delay in attacking the other person can only be understood in understanding the attacks and the psychological kind of torture that they've gone through as a victim And there was a lot of time spent on that in this trial.
Yeah, and again, the defense put on a number of experts to lay out that defense, and we'll get into how that played out. Ultimately, this was a 67-day trial, and they don't try cases, every single day of the week. Typically in Maricopa County, it's 4 days a week over a span of several months. And you touched on earlier the media presence that was there. I do recall the days at the courthouse when this trial was going on. Media everywhere, people flocking to try to get a seat in the courtroom. Outside the courthouse steps were packed. I mean, it was just
a line.
Media friends
trying to get in, and it was like the hottest ticket in town if you could sit in and watch a day of trial.
Ultimately, the jury did convict Arias of first-degree murder. And this was a death penalty case, so the prosecution had sought the death penalty. They put on a penalty phase of the trial. The original jury who found her guilty, was unable to reach a unanimous verdict as to death, meaning they could not agree on whether she should live or die. And so they had to impanel a second jury. The guilty verdict still stood. It's just for the purpose of penalty. I know we've talked about death penalty cases, and that's how it works. There's a guilt phase, and then there's a penalty phase. They impaneled a new jury just for the penalty phase, and that jury, again, unable to reach a verdict as to whether the death penalty ought to be imposed. And so at that point, Arizona law requires then that the court impose either a life sentence without parole or life with the possibility of parole after 25 years. She was given natural life, meaning no parole for Jodi Arias. She's going to be in prison for the rest of her days, unless, some appellate court or other circumstance, changes that outcome. But as we'll get into, this Court of Appeals affirmed her sentence, and so she sits in Perryville Prison today.
And we've talked about this, that there's an automatic in this type of case. There's always going to be an appeal.
That's right. And because it wasn't a death sentence, it doesn't go to the Supreme Court, the Arizona Supreme Court. It was a life sentence, and so that is handled by the Court of Appeals, which is the next level up above the trial court.
Yeah, and it's always interesting to read these kind of decisions by that Court of Appeals or by the Supreme Court, because some of these cases just don't have much, to argue, right? They're coming up with these arguments about what happened in the trial and what was inappropriate, where this one really had some legs, in my opinion, as far as what went wrong in the trial, as far as from the state's perspective, meaning the prosecution's perspective, and whether or not that affected Jodi's right to a fair trial, which is fundamental to the criminal justice system.
Right. So on the appeal, the appellate court looks back at what happened at the trial, and they determine, was there anything that occurred at the trial level that was so wrong or inappropriate or illegal or whatever, to the extent that a new trial should be given, okay? There were a number of issues that the appellate court addressed, but there were two major issues that the court put out in a published opinion. And what the importance of that is when the appeals court publishes opinion, that becomes Arizona law. It's a form of law that other courts can then rely on for precedent and its rulings. And so today in our discussion, we're going to focus on those two things. And those two issues are, number one, the media attention that this got during the trial. Did that somehow impact Arias' ability to present or to have a fair trial? Or was her due process right to a fair trial interrupted by all of the media and the chaos? The second issue is, again, prosecutorial misconduct. I know we've talked about this a lot. I know we've talked about Juan Martinez a lot. I don't want this to be the Juan Martinez show. The other day somebody asked me, do you have a personal beef with Mr. Martinez? And I want to be very clear. No, I don't. The problem is, because we look at a lot of these homicide cases or death penalty cases in Maricopa County in recent years, the fact is his name comes up. Frankly, I don't really want to talk about him anymore. But he has raised so many issues that we have to talk about him.
Yeah, and it's really sheds a lot of light, I guess. It's sometimes a very clear example that we can use of things that happen in trial, whether they're good or bad, right? And he certainly had a particular style, which really, I mean, we're going to talk about the trial publicity part of it and whether that interfered with her right. But really, the vast majority of this decision talks about the prosecutorial misconduct. Really, they're talking about whether or not it existed, whether or not it was systematic or permeated the whole trial, and whether or not that means she should get a new trial.
That's right.
Right. And so kind of going with that trial publicity piece of it, right, is Jodi's team. They argue that the superior court, and it's interesting, she denies that the publicity before trial caused her any prejudice, meaning unfairness in the case. She contends that the Superior Court improperly permitted media access to the courtroom during trial, including a live stream broadcast of the proceedings. She asserts this media coverage deprived her of a fair trial and an impartial jury.
I do think that was interesting because on the one hand, Jodi, pre-trial, was all about the media attention, right? In fact, there's commentary by the court that says it's almost as if she wanted to try the case to the public ahead of trial, but yet when the trial starts, she's now complaining, I don't want the public to be involved in this. How do you argue that?
Yeah,
How do you argue that?
In fact, it was interesting. This court of appeals quotes her lawyer in an evidentiary hearing complaining about this, right? So basically saying that she seemed primarily focused on the PR aspects of the case and preferred trying her case in the press.
Right. Now, you have to balance two legal issues here, or two legal principles. One is the right to a fair trial. The other one is the right of a free press, right?
Free speech.
And free speech. The ability to allow the public to scrutinize what goes on in a courtroom. And this, I guess, is a little bit of a debate that we can have, right? Do we want a courtroom to be closed and private where there isn't going to be these prying eyes and these disturbances from the media? Or do you want it wide open? And the argument, I suppose, is if we close the doors, how is the public going to know that what goes on in there was fair or proper or the right thing? I'm a fan of an open door policy to the courts. I want everybody to see what's going on.
And that's really what the court says that is the law, right?
And that's the law.
Unless there's compelling reason not to, it needs to be open for that exact reason, right? If you live in a society that has closed trials, we all watch a guy go in and he comes out and he's guilty and we have no idea what happened in the middle. That's just not a free society to understand that we can trust the system and what happened. At the same time, the counter argument, right, is that we have a jury system where we have people who are just normal people sitting in there hearing very complex arguments, very, very difficult facts, and making a huge legal decision for this person, guilty or not guilty, in the first phase. Second phase, if they're found guilty, death or life in prison.
It's an interesting point. So the jury process itself makes it public.
Right. Well,
good argument.
But it also is the danger of the publicity, right? Mm-hmm. Because they can be influenced. Especially right now, right? You've got phones. The other day something popped up and my wife was like, oh my gosh, I got to tell you this crazy story about this Bachelorette actress. I'm like, oh yeah, I heard about it.
Yeah, we already know.
Even though I could not care less about the Bachelorette and I don't watch it, I knew what had happened. So think about that with trial right now, where everybody's going to know and they're going to have an opinion, right? So you aren't going to hear like a fair, just totally objective view of what happened. Somebody's going to give their take on whether this person's guilty or not. And then now that person sits in a jury box and says, yeah, I've heard about the case. And I can be fair and impartial and not let that affect me. That's very dangerous.
Well, and what's interesting, I guess, as you talk about that, I mean, this case was done in the pre-TikTok era. Can you imagine Jodi Arias now in the TikTok world that we live in? That would be wild. So moving forward just a little bit, in terms of what the law is, right? We talked about this First Amendment right to, a free speech and access of the press, and then the right to have a fair trial. In a situation like this, what the law says is when you're claiming that the media exposure affected your case, you've got to show prejudice. You've got to show objectively that something happened, something occurred that caused your trial to not be fair. And the court warns of a carnival-like atmosphere, and then it cites to 3 U.S. Supreme Court cases where there was more of a carnival-like atmosphere, where the media was actually sort of falling over itself in the trial, stopping the trial, doing these things. And the Arizona Court of Appeals says, that's a circus. What happened in Arias was not a circus. And it was because of the restrictions that Judge Stevens had put in place.
Right.
Camera was only allowed in the courtroom. They couldn't take photographs like still photos with the shutters clicking during the presentation of any evidence. They had to make sure that the jury wasn't visible, and they had to, keep it very professional. And so the court laid down these ground rules, and the Court of Appeals says, "Hey, that's how you do it."
And they were right out of the rules of criminal procedure that this judge said, you guys have to abide by these rules, and she kept good track of it. And this is an interesting point, too, that this is how legal analysis works, right? Is you say, well, we know that the standard is that if it's a circus-like atmosphere, then potentially it could have interfered with the trial, right, or her right to a fair trial. And so you say, well, what does that mean? Circus-like atmosphere. And so you get 3 cases, and they say, here are 3 cases where it was found to be circus-like, right? And it's interesting to compare those facts. Like you said, then they compare those facts to these facts and say, was it the same? And so under these 3 cases, just really quickly, one of them, the first case, the police department disclosed a 20-minute video of the interrogation. A local television station broadcast the defendant's confession 3 times before the trial started. The real trial had occurred when a substantial portion of the community's population saw the defendant admit guilt on TV, right? So that was number 2, the first case. The other 2 cases were more what you were talking about, where it was a circus. They had media on the other side of the bar. So if you've ever been in a courtroom, there's like a half wall generally that has, some doors that the lawyers go in, and only the lawyers and the defendant are beyond that, right? And the court staff and the jury, where apparently in this situation, they had media behind the bar sitting with the lawyers who could then not confer with their client, who were then walking in between the witness statements and making all kinds of stuff, And they're saying nothing like that happened in the Arias case.
Yeah, and during the trial, Judge Stevens was able to keep an orderly process moving. Now, what's interesting, though, is the Court of Appeals specifically says this: Arias has not cited, and our review of the record has not revealed, any evidence to suggest that the impaneled jurors were actually prejudiced by the media coverage. Now, I get it, but let me ask you this, though. If the media coverage in the Arias case is not enough to warrant, a new trial based on publicity and exposure during the trial, is there ever going to be one? I mean, I can't think of another case that, OJ, of course, comes to mind as a big media case. That was, I think, the original, right, where everybody was watching. But is there ever going to be a circumstance?
I think the point is, it's not because there was too much media, right? Or too much attention. I think that's a risk. That's dangerous as far as a fair trial. But I think what the court was saying was, that doesn't mean it's unfair, right? And so they have to find the next stage to say, what about that in this case made it so either a juror couldn't be fair or they were affected, which I thought was interesting, right? Because they broke down problems where these rules that the judge laid down got violated, right? You had somebody yell in the middle of the from the gallery saying, "I wish you were dead, Jodi." You had the defense team being threatened, death threats constantly followed around in public. You had a juror multiple times. You had jurors' faces being shown, even though they weren't supposed to. But they talked about how each time one of these things happened, the judge immediately addressed those things. And so that's where I think it gets a little closer to the issue, right? Where it's saying those were actual things that happened. that somebody could argue may have affected a juror's willingness to go against what they knew public sentiment was, right? Which public wanted her head on a plate.
I know.
And you're telling me that's not going to affect a juror who now realizes their face could be shown on
But
TV?
here's this, though. The court took it upon itself to individually question the jurors, I think more than once, to see, have you been affected? Are you doing okay? Is there anything about the media coverage that's affecting your verdict? And every juror denied any sort of concerns. And so because the court took the step to inquire and ask, and the jurors are saying, no, I wasn't affected, or I'm doing okay, then the Court of Appeals, has a record to go on that says not only, did the court, control what was going on in the courtroom, but she asked the jurors, and each juror says, no, we're fine. Nothing impacted us. Now, you have to judge the credibility, I suppose, of each of those jurors. But at the end of the day, as the Court of Appeals says, there's nothing to show that the media exposure did anything to affect the outcome.
That's it, right? I think that you say, did it affect their ability, to be fair and impartial? Again, you and I can all day talk about whether or not people are going to be honest about that. But when you're directly asking them, is this affecting you? And is it going to affect your verdict or anything like that? It's hard for them, the defense, to show that it did affect them, right? That's what they're saying. They have to show the prejudice. They have to show the unfairness and how it made it so that this juror made a decision that they might not otherwise have made. And they have, like you said, a record to just the exact opposite of that.
Right. Now, so that's from the court perspective, okay? That's a court issue that the judge has to deal with the media, right? That's not the defense. That is not the prosecution. Now we'll get into Martinez about, his antics outside the courtroom, signing autographs, posing for pictures, and other things. But that's prosecutorial misconduct,
Separate,
related to the media. Let's shift gears for just a moment before we get into prosecutorial misconduct. Let's talk about the difficult task that the defense had in presenting a self-defense argument here, okay? Because, you have this ever-evolving story from Jodi Arias saying, I wasn't there, I was in California. Then it was people broke in and they did it.
It was the
and
one-armed
then it
man.
was, right, the one-armed man. And then it was, I did it, but I acted in self-defense.
And now I'm sticking with that.
And now I want to go with that. I've prosecuted like aggravated assault or homicide or other violent offense cases is the word I'm looking for. I've also defended, and I've defended many clients in self-defense cases. It never is easy when there are multiple versions of the story out there. Talk to us about that. What's your experience? What's your, how do you sympathize with Kirk Nermy and Ms. Wilmot there in terms of what the task that they had to perform?
Yeah, we talked about this. You work with what you got, right? I think that's what comes to mind on this case. The facts were tough, I think, for them. I think you don't get to change that. And this isn't the type of case, there's so many types of cases where you'd say, well, why would the defense take this case to trial, right? Because they could plead guilty or do whatever. And in our, many of our cases, that makes sense. If the facts are completely obvious, our job is to minimize damage, negotiate something that's better for our client. Not an option in a case like this. There is no plea offer. It is going to trial, and that's how it works. And so when you're in a case like this and you have a client who has made multiple statements, you do what you can do, which I think the self-defense argument, the battered partner or battered woman syndrome, is really the defense you make for that, right? Because that's why they lie. That's why they made stuff up, is because they were scared, and because, you have to give an explanation, but it's just never good, right? It's never helpful to say, she said, I'm trying to convince you that she's a victim in this situation, but I also have to admit that she just told two false stories until she's trying out stories, right? That's how it looks to a jury a lot of times.
Kind of testing the waters
What
on
lands, and it's just hard.
Well, and it makes it even more difficult when she's out there, giving now media statements pre-trial. And the more a client talks, and this goes back to some of our earlier advice, the more a client talks, the more difficult my job becomes, because now I have to somehow deal with each of those statements.
Especially in a case like this where her theory is changing, right? It's like if she makes one statement that now conflicts with, the theory you're using, that's just, they get to use that.
It's also difficult, notwithstanding her statements, but take a look at the physical evidence. I mean, Travis was brutally murdered. 27 stab wounds, slit throat, gunshot wound to the head, blood all over the house. It's one thing to, have a gunfight in the street, at let's say, where between two people where somebody allegedly pulls a gun on another guy and the other guy fires and says, I did it in self-defense. Okay. That's more defensible. That's easier. But when there's all of these wounds and wounds to his back in particular, defensive wounds to his hands. I mean, like you said before, we don't get to choose the facts. Unfortunately, by the time I handle a case, it's over, right? The facts are done. And so I've got to pick up the pieces and say, what can I do with this? How can I craft a narrative that will give my client the best chance of success at trial?
And that fits the facts. Right. And that's what makes it hard when she keeps introducing more of them, right, into the narrative. Now, I think my perspective has changed a little bit on this. I don't think it's always a bad thing to have your client say things. I mean, I should be careful saying that. It's very rare. But kind of in the media, if stuff's getting out there. But in this type of a situation, especially with her, I think she, this is my take. She, and this is what the jury believe, I think, was that she's a type of person who knew how to get what she wanted from people. People like her.
Yeah.
And she is kind of able to manipulate, right, people. And I think she kind of thought that would happen, that she would make these statements. And she's very popular.
Sure. Oh, she's got a fan club.
She's got a huge fan club. What does she do? Art, and sells. She makes tons of money selling her art right now. I think she thought that was all going to play well for her.
Right.
And, again, we'll get into the prosecutorial misconduct part of it, but that was used, right, in the case against her.
Yeah, and I just have to put this out there. One of my good buddies is a big Jodi Arias fan. He's somehow infatuated with Jodi Arias. And so I say that because she does draw a crowd. She has her own group of followers, and so I think her point about, or your point about her being able to manipulate the situation based on her ability to talk or charm people, maybe that's what she was thinking. Now, objectively, as her defense lawyer, it's, you kind of see right through that sometimes.
And you can see why Kirkner was frustrated with it when he was in that evidentiary hearing, saying, I'm sitting here trying to defend this person, and she keeps going out there and throwing more stuff in the wind that I got to deal with.
Right. All right. So we'll close it out with the big issue, the final issue, prosecutorial misconduct. We've talked about what that means. I'll just set the stage again. Prosecutors are government actors, okay? They are special in that their job is not to win. It should not be to win. They represent the state, the government, and the government has to protect the people, the rights of the people, and do what is correct. And the ethics rules call them a minister of justice, okay? My own personal opinion is Mr. Martinez long ago forgot what that means, and that is borne out by his conduct here, because he just, I'm going to say he went off the rails in areas.
And it's not just us saying that, right?
Yeah.
This is the Court of Appeals repeatedly in this finding, in this decision, saying it. And we're going to talk through the ways that, the Arias team argued that he had prosecutorial misconduct. And almost at the end of each one, the decision is, yeah, He grossly forgot his place and did the wrong thing here.
So you earlier talked about legal reasoning and how judges come up with decisions, how lawyers engage in that thinking. The rule here is prosecutorial misconduct is reversible error, meaning you get a new trial only if a reasonable likelihood exists that the misconduct could have affected the jury's verdict, thereby denying the defendant a fair trial.
Yeah, we'll come back to that.
So that's the stage, okay? And so then what was the misconduct? So it's kind of batched in different groups. So
and before we get
ahead.
to that, this is just a few of them, right? I mean,
it's not everyone.
Yeah, I mean, the judge talks about there is a long list that was presented by the Arias team. We're just going to talk on the biggest ones because we only have so many words, to use in this, and it gets the job done. And so that's an important point, right? Like, there was more than this.
Right. And so much of it was on how Martinez questioned witnesses, starting with Arias herself. She was on the witness stand for 18 days.
That is crazy.
And she was cross-examined for 7 of those days. And Martinez's method of questioning her in particular was very demeaning. It was attacking. It was just completely improper. And so, for instance, the line of question is, the prosecutor asked Arias whether she had ever told the victim that her sister was, quote, dumb. When Arias answered, yes, I called her dumb and stupid, the prosecutor responded without objection, did I ask you whether or not you called her stupid, ma'am? So the question was dumb. She adds stupid. And he then will spend the next several minutes asking her, well, I didn't ask you whether she was stupid. I used the word dumb. And so it was just this wrestle that would go on and on.
Yeah, and this is a pattern, right? We'll talk about the other people that you talk to about that. And, maybe I'm jumping ahead, but sometimes, and I think part of the mentality of people when they were watching this, they were like, yeah, go get her. She's a freaking murderer.
It's a show trial.
Right? Just go after her, attack her. And it's one of those things where we need to understand the position, just like you said at the beginning, of a prosecutor. That is improper. Not because we are, proper and trying to be prim and proper, right? It's because we are protecting her right to a fair trial.
That's right.
That should be his goal. And that might sound strange to people, but that's what a prosecutor is supposed to do.
Right. And so he aggressively questions her in a demeaning manner. And the defense team, kudos to them, during her cross-examination alone, they moved for a mistrial 6 times.
And you see that again with all these things too. They tried so much, and we've talked about this with other defense teams where they just fail to object on things. And we'll talk about that. They even kind of say a couple times they didn't object, but it's like, how much can you object to one
right
thing? And it's, they tried so many times to get a mistrial, I think, properly.
Yeah, and the judge heard those objections, and her method to remedy that was simply to tell the prosecutor, hey, be more professional, move on, take a breath. So, and the court allowed trial to continue. Another area, Dr. Samuels was a mental health expert that had evaluated Jodi. Without any basis for this, Martinez begins to accuse Dr. Samuels, of having a romantic relationship with Arias and having some sort of feelings for her, which there was no reason to believe that, and yet he is interjecting that as a way to impeach the doctor by saying, well, you're only saying this because you're in love with her. I mean, it's insane.
He did the basis of it was because he gave her a book.
He gave her a book,
because
he says, look, I thought she may have been suicidal. I was concerned. I gave her this book.
It was about self-esteem. I'm trying to help her because I feel like she was suicidal. That was it. And he just repeatedly denied anything. And yet, it's not just that he kept doing it. He just would state it as fact after that.
Right.
And just say, well, obviously what he said.
You love Jodi, don't you?
Yeah. Right. And even some of the questions from the jury showed that they adopted that. Like, if you just say it enough, they'll start to believe and say, well, why did you have
a juror asked a question whether he, quote, always developed such a fond relationship with his evaluation.
Even though he had repeatedly said, I don't have that.
So that, I believe, proves the point that Martinez's method infected the trial, because now you have the jury that's grabbing onto this false narrative that he created out of thin air, right?
Yeah.
And then there's another expert. She was the domestic violence, battered woman syndrome expert, Laviolette, Dr. Laviolette. Martinez asks questions like, "Are you angry at me?" And just goes on to sort of, he's, in his words, sparring with the doctor. So he's having this sort of verbal fight with the doctor.
He even says, "You want to spar with me?"
Right.
To the doctor, who's just like, and this is the other thing, they talked about the tone of Martinez, right?
That he's not captured in the record.
Right, it can't be, right? But I think the defense attorney, again, did a good job of saying, look, I know this isn't going to show on the record. He is just immediately yelling at our witnesses. Mm-hmm. And in fact, that's what that witness said. As soon as Martinez started questioning, said, "Are you mad at me? Why are you yelling at me?" Right. And then he would say, "Well, do you have a hard time remembering things? You can't understand my questions? Basically, are you an idiot?" To this person saying, "I just have a hard time in this environment where I'm being yelled at," right? And
in a courtroom. And we go back to the media exposure of the trial. I believe that by this point, now I think Juan Martinez, that's generally his style. But by this point, and given this microscope that he is under, and a huge crowd of people, it pumps up his ego. And now he becomes a character in the courtroom. And he's got a fan club.
Yeah.
And he's got a following. I'll just finish out with the witness questioning. Overall, the Court of Appeals says the record reflects that the prosecutor consistently displayed a hostile demeanor toward the defense witnesses.
Yeah.
And then that evolves, as I'm saying, and I'll let you jump in, as to the publicity. So he's out there on the courtroom steps taking pictures and all of that. Go ahead and take that.
Well, before I was looking back at this before Laviolette, going back to Samuels. And again, it's not us saying that this is improper. This is the Court of Appeals saying this is an example of the exchange that permeated the trial. Okay, that means it was constant, right? On the record, it is clear that the prosecutor maintained an impermissibly aggressive and combative demeanor with defense witnesses, and these are just experts. They
don't have a dog in the fight.
They're yelling at them, and the court's repeated admonitions were insufficient to curtail his unprofessional conduct. So he would be stopped, by the court, and then you immediately just start doing it again.
Yeah, judge says, "Hey, knock it off," and he says, "Okay," and then he goes right back at it.
Yeah.
So then move into the publicity.
Yes. So this is one where they talked about that they thought it was improper, and I don't have it right in front of me, but basically that it was improper for him to be putting himself as this self-aggrandizing position as the prosecutor. And again, I agree with you. I think exactly what was happening was he was just getting fed, right? He was just getting fed to say, "I love that you have no mercy and no decorum and you're following no rules because we already know she's guilty," right? Which is just the whole problem behind due process, right? Is that if we say we already know she's guilty, so it doesn't matter how we go about the trial because we already know it, trials are a sham. They are useless. And so they were talking about how he would, I loved how you mentioned taking pictures.
Yeah, I'll read it from the opinion. Yeah. Specifically, the prosecutor had been seen on the courthouse steps, posing for pictures with spectators, signing autographs, appearing with at least one media personality. And when confronted by this, he says, quote, "What happens outside the courtroom is not misconduct." That is his mentality. He's like, "Judge, as long as it's not in the courtroom, I can be whoever I want."
The court says, that's made up.
Right.
Right? But he just states a rule like it's a rule, right? He just says it like it's a rule. Oh, guys, don't worry about it, because the minute I step out of the courtroom,
I become Juan Martinez the man.
It doesn't apply.
Yeah.
Right?
Well, the Court of Appeals says a prosecutor's ethical obligations do not stop at the threshold of the courtroom.
Yeah. So to the contrary.
Let that be a lesson to all the prosecutors in the world and to the public. I mean, Martinez loved this, and he played it up.
Maybe he knew it was his last. I don't know. But it says, On this record, it is clear that the prosecutor improperly engaged in self-promoting conduct. His efforts to gain personal notoriety were beneath the office he held as a representative of the state of Arizona. And I think that is the key, right? It's fine to try to be famous, right? That's fine. But not because you are the prosecutor in a case that you have been entrusted with as a minister of justice.
Yeah, I think the prosecutor's role is a sacred one, and
It is.
you have to look at your job as though I have to do the right thing. If the evidence shows that somebody committed a crime and I can prove it, then my duty is to prosecute that crime. But if the evidence shows otherwise, and maybe there isn't enough evidence, even though the guy may be guilty, but you don't have enough evidence, your obligation is to do justice, whether that is diminished consequences or a dismissal or whatever it is. You have that special duty. And defense lawyers, criminal defense lawyers, don't have that same duty.
Yeah, we talked about that before.
We defend clients. Now, we have to do that ethically.
Honestly, we can't lie.
Correct.
Yeah, absolutely.
But we don't have we don't have a duty to do justice. We have a duty to defend a client.
Even when the prosecutor is 100% certain that the person that they are prosecuting is a monster, they still have to do it within the rules that protects that monster's right.
That's right.
Monsters still have rights. Right. Yeah. In America. Yeah. Right. It's that prosecutor's job to make sure it gets done in a way that protects their rights. And that's interesting.
Right. And so I guess conclude this discussion with, the way he presented evidence, the way he characterized witnesses. The Court of Appeals then says, and this is where I think I'm a little frustrated with the system. The court points to dozens and dozens of instances and says, misconduct here and there and everywhere.
You said he did this? Yes, that was totally wrong. He shouldn't have done it. It's totally improper. You said he did this? Yes, totally improper. I'm sure, exactly. This is the
So Schwartz says prosecutorial misconduct undeniably permeated this case. Rather than a few isolated missteps, a pattern of intentional misconduct saturated the trial. And so when I read that, I think, oh, they're going to overturn this verdict based on prosecutorial misconduct. Oh, no, ladies and gentlemen, they didn't. They said, no problem. There was overwhelming evidence of guilt. Therefore, this is harmless error in that what he did was wrong, and he should be punished. And I'll say that they did refer Mr. Martinez to the bar, and we talked about in previous episodes. He was sanctioned. He later then was served with a bunch of other allegations, including sexual harassment and other things, and he stepped down. He gave up his law license. So the court here says, just to kind of put it in a box, terrible, horrible, permeating misconduct, but overwhelming evidence of guilt. Therefore, it didn't impact the verdict. I don't know how you get there.
It drives me so crazy because you go back to the very beginning of what you said the standard is, right? That if there was prosecutorial misconduct, the standard is if there was reasonable likelihood that it changed the outcome, right? That's right. Basically, you're telling me that this permeated, and we didn't even scratch the surface, to be honest with you. There's a whole section about how he totally improperly, in his closing argument, told the jurors that if they didn't convict, they were complicit in the murder.
Right. They said, Jodi's fooled everyone. Are you going to be a fool?
Are you going to carry the gas cans for her?
Yeah.
Are you going to carry gas? Don't fall for it, right? You're not allowed to do that as a prosecutor. It is Prosecutor 101 that you cannot put the jurors in the shoes of anybody, a victim, no.
So it's frustrating because, sure, you can use metaphors and arguments and things like that, but Martinez always took it one step further and says, this next thing, he crossed over that line. And so the Court of Appeals at the end of the day says, yes, widespread misconduct, but the verdict stands because overwhelming evidence of guilt. Now, my favorite part of the Arias opinion is the 2-page concurrence that was offered by Judge Jelks, who says what you and I say when we read this, just Yes, he still comes to the same conclusion. You can sum up the concurring opinion in what I think is one question. Are we permitted to suspend and abuse the rules of professional conduct so long as a defendant's guilt is overwhelming?
If so, why do we even have a jury? Like, aren't we just replacing the jury with the Court of Appeals opinion of how strong the evidence was? Because we just admitted that the way it was all presented, sure, you can say that this evidence was presented, but they still had to come to a decision. And to me, it's not just a question of whether or not it would have changed the outcome. It doesn't say that. It says could have changed the outcome. And I think that could have. But I think even if you say it couldn't have because the evidence was so strong, how are you not weighing to say, we in America are going to say even people that have strong evidence against them, that it's obvious that they committed this, they still have a right to a fair trial. I think that, for me, that's what it comes down to.
And I agree with you 100%. And look, I spent 8 years of my career as a prosecutor, and I wasn't perfect. I'm not perfect. I don't claim that I did everything right, but I do believe that I had a decent sense of what justice is, and I think you're the same way. But I think Martinez lost total sight of what that means to be a minister of justice. And to me, it is a step in the wrong direction for the Court of Appeals to say, yes, this was terrible, horrible things that Martinez did, and allow the verdict to stand. Now, is Arias guilty? I don't know. I mean, there certainly was a lot of evidence. It was difficult for the state or for the defense to defend it. But the state still has to prosecute things in the right way. Yeah, and that's the lesson.
Where people get confused for us on that, right? They're like, wait, you guys are arguing for Jodi Arias that she should be released. No, that's not what we're saying. We're saying, I don't think the trial was fair. And I believe the trial needs to be fair. And so even if it's obvious, I think she should have gotten a new trial. That's just my opinion.
Whose fault was that? Should Judge Stevens back in the middle of the trial have said, I'm granting a mistrial?
One of those mistrials, those requests.
Probably, but the Court of Appeals upheld her decision not to. So how do you look back and say she did the wrong thing? I think you and I, what we're saying is we would have liked to have seen the court do that. Now, the practical implication of that is you got to start this thing all over again. Can you imagine?
I think that's the pressure, too. There was so much momentum on this case, she would have been under a lot of pressure. And I'm not saying that's why she made this decision not to do mistrials. She would be taking a lot of heat for saying, I'm gonna start this thing over again.
Yeah. Well, good discussion. I hope this provides everybody with a decent insight or a new insight into the Arias case. And so, Ryan, appreciate you. Glad I didn't do this today. We loved it. Okay.